The defense in the Senzo Meyiwa's murder trial has accused the state of engaging in a trial by ambush. This follows after the state introduced new evidence as court proceedings were due to get underway. The Senzo Meyiwa murder trial resumed in the High Court in Pretoria on Monday morning after the trial was postponed for 2 weeks due to evidence related to the cell phone communication between all the accused dating back to 2018. The 27-year-old Orlando Pirates goalkeeper was fatally shot at his girlfriend's home in October 2014. To discuss this, I'm joined by Legal Analyst Mpumelelo Zikalala. Mpumelelo, thank you very much for joining us. In the case of the Senzo trial, what legal ramifications do repeated adjournments have on the judicial processes and the rights of the accused?
Good evening to you and also to your viewers. Well, they deal directly with the rights that have been afforded to the accused. Under Section 35 of the South African Constitution, an accused has a right for the trial to start and end within the shortest or reasonable amount of time so that they do not suffer any adverse things which are going to be there. Also, another thing that comes in is the effect on the family of Senzo Meyiwa, because what they're looking for is foreclosure. So the long postponements that you keep on enjoying and the many other things that are there are not really assisting anyone, and not to mention the legal costs which are going to continue to incur from the side of the accused. So it's important for this matter to end as soon as possible. But in doing so, we must give the opportunity to the state to provide all the evidence that is there, and for that evidence to be disputed by the defense.
How does the sudden disclosure of what they are describing as crucial information, referred to as an ambush, impact the fairness and transparency of the trial proceedings?
It goes directly into that. Remember that when a trial actually starts, there's a pre-trial hearing which is held. During the pre-trial, that's when all the documents are going to be handed over. This is to allow the legal practitioners to go and consult with their respective clients to come back and formulate a defense. Now, if you are going to do that in a piecemeal approach, you then put the accused in a very bad or prejudicial situation, because they're not able to consult comprehensively, and they're doing so in piecemeals or in shorter sessions, which is not going to assist them in the formulation of their defense. So it does probe a bit of a problem if evidence is going to crop up in here and there. Secondly, it's also a disadvantage because you remember that there are other witnesses that have gone into the witness stand. You would have found that there may be questions could have been raised emanating from the document that they've received now. Now, you don't have an opportunity to do that. In order for you to do that as a defense, you need to make a special application to the judge to recall the witness. That's further delaying this trial, as it is further delayed as of now. So it does put them in a very bad situation, and it is highly prejudicial to them.
I know it's already happened, but should the judge have intervened or cautioned the state about their behavior in withholding information? And how do you think this would impact or affect the integrity of the trial?
Well, the judge would be doing his job. He's there to make sure that the trial is able to move on as quickly as possible, that all the rights of the individual, that of the accused, that of the state, and that of the victim, which is the Meyiwa family, are protected. And if there's anyone who's not playing or doing things according to the rules of court, then they're within his right to say, I'm going to caution you, I'll make sure that you're able to provide the information which is required. Maybe we also need to take a step back and say, maybe what ought to have happened in this case was a pre-trial at the start to say, let me make sure that before we even start the trial and call our first witness, as we are doing it from scratch, I want the assurance from you that you have received all the information, you've received all the affidavits, there's nothing which is missing. So you're not going to stand up in the middle of the trial and request for further time just because something has been handed over to you last minute. I think maybe to try and avoid these type of things, that's the process in which they need to engage in moving forward.
How might these delays and lack of disclosure by the state influence the outcome of the trial?
Not necessarily, because the vetting process, or the process of determining who's telling the truth and who's lying, which is something which is done at a much later stage. What is being done now is the collection of the evidence and making sure that the evidence does go in order for it to be evaluated at a later stage. So this will not have an impact, because at the end of the day, once a ruling has been made, the judge has got to find cognitive reasons of saying, this is how I arrived at this particular conclusion. So I don't think these proceedings are going to have any impact on the final judgment. The only impact in which they're going to have is that it's going to be delayed. The sooner the judgment comes in, the better. And with all these interjections coming in, postponements taking place, one is starting to give up hope that we're going to wrap up this trial by the end of the year.
Okay, just one more question before I let you go. What legal implications arise when potential witnesses who were present during the incident choose not to testify in court? How does this impact the search for justice in the case?
Well, it weakens the state's case because without a witness being available to provide evidence, then it becomes a problem. But again, not only that, them refusing, even a person forgetting or even a person passing on, is that it is a blow on the state's case, which is why it's important that the matter must start and end within the shortest reasonable amount of time. But just make sure that you have quality and quantitative evidence. And the only way in which you'll be able to do that, make sure that you're able to investigate the matter as soon as possible and bring those to book at a much earlier stage. Not in this case, which has taken a decade in order for the accused to go into the accused box.
Mpumelelo, thank you very much for speaking with us.
Thank you very much for hosting.